After studying this module, we shall be able to understand different types of legal systems prevailing in the world, outline the legal environment relevant for international business, and understand the concept of legal risk and ways to prepare for such risks.
Laws of the land directly affect the international business wherever they operate. Legal environment refers to the legal system working in a country. The legal system is further defined as the rules and laws that regulate behavior of individuals and organizations and which the nation states consider binding on themselves. Failure to comply with the laws means that penalties will be inflicted by the courts depending on the seriousness of the offense. This raises two interesting characteristics of international law. The first is that law belongs to individual nations and international law only exists to the degree that individual nations are willing to relinquish their rights. The second is the lack of an adequate international judicial and administrative framework or a body of law which would form the basis of a truly comprehensive international legal system. The international business is also subject to political decrees made by government both in home and host countries. Home governments can apply pressure not to deal with disapproved parties. These measures may include the refusal to grant an export license or withdrawal of export guarantee cover. The host government may take measures like taxation, ownership controls, operating restrictions, or expropriation. Thus, for example, the advertising laws in Germany are so strict that it is best advised for the international marketer to get himself a good legal counsel before framing his advertising strategy in Germany. In fact, all over Europe, there exist different set of laws preventing promotion of products through price discounting. These laws are based on the premise that such practices differentiate buyers. This example reflects the influence on only one of the variables of marketing mix. Laws may exist for other variables of marketing mix such as product, price, and place. Thus, monitoring the legal environment is very important. There are two categories of international law: public law or the law of nations, and international or commercial law, which is evolving. International law pertains to trade and other areas that have traditionally been under the jurisdiction of individual nations. Laws have an important influence on the decision making of firms, and an international manager should be aware of the legal systems and the laws that are in force in various foreign countries.
Legal environment refers to the legal system working in a country. The legal system is further defined as the rules and laws that regulate the behavior of individuals and organizations and which the nation states consider binding on themselves. Failure to comply with the laws means that penalties will be inflicted by the courts depending on the seriousness of the offense. Laws have an important influence on the decision making of firms, and an international manager should be aware of the legal systems and the laws that are in force in various countries. This raises two interesting characteristics of international law. The first is that law belongs to individual nations, and international law only exists to the degree that individual nations are willing to relinquish their rights. The second is the lack of an adequate international judicial and administrative framework or a body of law which would form the basis of a truly comprehensive international legal system. International business is also subject to political decrees made by governments both in home and host countries. Home governments can apply pressure not to deal with disapproved parties. These measures may include the refusal to grant an export license or withdrawal of export guarantee cover. The host government may take measures like taxation, ownership controls, operating restrictions, or expropriation. There are two categories of international law: public law or the law of nations, and international commercial law, which is evolving. International law pertains to trade and other areas that have traditionally been under the jurisdiction of individual nations. The legal system of a country is of immense importance to international business. A country's law regulates business practice, defines the manner in which business transactions are to be carried out, and set down the rights and obligations of those involved in business deals. It takes an added importance for IB on the ground that since no single uniform international law governing business transactions exists, hence the study of legal environment helps the marketer to explore the laws of each country individually and makes him prepared to face the complex, varied environments. Certain treaties and agreements are respected by a number of countries that profoundly influence international business operations. A treaty is a formal agreement between two or more nations in reference to peace, alliance, economies, etc. Treaties can cover almost any subject of mutual concern to nations, from ending war and conflict to the elimination of nuclear weapons to the promotion of trade and investment across national borders. Treaties may be bilateral between two countries or multilateral among several nations. A convention is a treaty on matters of common concern, usually negotiated on a regional or global basis, open to adoption by nations. Let us discuss some of the important treaties and conventions. Treaties of Friendship, Commerce and Navigation, FCN treaties. These are bilateral agreements that provide a broad range of protection to foreign nationals doing business in a host country. All the treaties are different, but typically state that each country will allow the establishment of foreign branches or subsidiary corporations, the free flow of capital and technology, the equitable and non discriminatory treatment of foreign firms, the privilege of acquiring and owning real estate, and most favored nation trading status for goods. The Treaty of Rome, 1957. This was the agreement which gave rise to the European Community or EU. Six member countries, Belgium, West Germany, France, Italy, Luxembourg, and Netherlands, signed this treaty to achieve the free movement of people, goods, service, and capital, eradicating barriers and creating a common market. Maastricht Treaty. It carried the European Union beyond what was initially thought to be possible. The treaty called for the creation of common currency and political union. The Vienna Convention on the Law of Treaties, 1980. This convention covers issues such as the interpretation, amendment, termination, and the rights and duties of countries party to a treaty which is in force. It has a bearing on international business because treaties affect trade between parties from countries that are signatories to various conventions. Paris Convention. The first international property treaty was the International Convention for the Protection of Industrial Property, better known as the Paris Convention. It guarantees that foreign trademarks and patent applications from signatory countries receive the same treatment, priority as domestic applicants. This principle of national treatment, an animating principle of all intellectual property treaties, eliminated the potential discrimination against foreigners in obtaining patents.
The Patent Cooperation Treaty 1970. This treaty supplemented the Paris Convention by establishing a centralized patent application process. The PCT application is filled on a standard form with the World Intellectual Organization WIPO, a UN agency. WIPO processes the common application and forwards it to the countries designated by the applicant. After the filing, the applicant will have up to 30 months to begin the processing the application in the countries in which it wants to obtain protection. This allows the applicant business to lock in one application date while giving it time to raise capital on the basis of patent filing. Failing to raise capital, the applicant can work away without having spent needless seems in worldwide patent processing.
Different forms of law are prevalent in different countries. The countries in transition from communism to market economy, mixed economy to market economy, and different types of totalitarianism to democracy, and capitalism may not have perfect business laws, and therefore the international manager should make his moves consciously and cautiously. Four principal legal systems are used in the majority of countries: common law systems, code law systems, Islamic law systems, and socialist laws. Code law systems or civil law. It originated in Rome in the 5th century BC. Under it, the judicial system is divided into civil, commercial, and criminal laws. They rely on statutes and codes for the interpretation of the law. There is very little interpretation in a code law system. Thus, commercial law has its own administrative structure. Code law uses codified written norms which are complemented by court decisions. The majority of the world's governments, Central and South America, some Western European countries, and some Asian and African countries rely on some form of code law system. Theocratic law or Islamic law, Sharia systems. In this case, law is based on religious teachings. They rely on the legal interpretation of the Quran and the words of Muhammad. Islamic legal systems hold that God established a natural law that embodies all justice. Islamic law was earlier a guiding factor for ethical behavior, but subsequently it was extended to commercial transactions. Under this law, a bank cannot demand interest on deposits, but they can charge a fee in the form of profit sharing with either the depositor or borrower, as the case may be. So it is difficult for multinational companies to operate in countries adopting Islamic law. Socialist laws. They were developed in the ex-Soviet Union after the Russian Revolution of 1917 and later assimilated by other communist states. They are distinguished by the influence of state ownership of the means of production, the pervasive influence of the Communist Party, and the ties between the legal system and national central planning. Since the breakup of the Soviet Union, socialist laws have mostly faded except in countries such as Cuba and North Korea.
Legal systems address both criminal and civil law. Criminal law addresses stealing and other illegal activities. Civil law addresses the enforcement of contracts and other procedural guidelines. Civil laws regulating business contracts and transactions are usually called commercial laws. International businesses are generally more concerned with differences in commercial laws across different countries. For example, who is responsible if a shipper delivers goods that are not up to standards and the contract fails to address the issue? What if the ship on which goods are being transported is lost at sea? What if the goods arrive so late so as to be worthless? What if a government limits foreign participation in a construction project after a foreign company has spent millions of dollars designing the project? Sometimes the boundary between criminal and civil law will also be different across countries. A significant example of the new uniformity measures of codification is the acceptance of the Uniform Commercial Code by 49 states in the United States of America, which codifies a body of specially designed rules covering commercial conduct. Laws governing intellectual property offer the most striking differences between common law and code law systems. Under common law, ownership is established. For example, are the officers of a company liable for actions that take place while they are on duty? When a chemical tank leaked in Bhopal, in India.
Let us discuss the various forms of legal risks which an international manager has to face. These are jurisdiction. Company personnel working abroad should understand the extent to which they are subject to the jurisdiction of host country courts. When a transaction crosses boundaries, which nation's law should be applied needs to be understood. If a dispute arises under such a contract, it must be heard by a neutral party, such as a court or arbitration tribunal. Therefore, the parties should be clear about which nation's law applies to them and should be specified in a jurisdictional clause.
All economic activity within a nation is governed by the nation's laws. When a transaction crosses boundaries, which nation's laws should be applied needs to be understood. If a dispute arises under such a contract, it must be heard by a neutral party, such as a court or arbitration tribunal. Therefore, the parties should be clear about which nation's laws apply to them and should be specified in a jurisdictional clause. In Japan, legal confrontations are very rare. Japan's population of lawyers is low, which makes it difficult to obtain evidence from legal opponents. Also, rules against class action suits and contingency free arrangements make it difficult to bring suit against a person or a company. These are disadvantages of the Japan's legal system, but it supports the cultural values of building long-term business ties based on trust. In the United States, there is a strong belief in the use of explicit contracts and a reliance on the legal system to resolve problems in business. In other countries such as China, a business person who tries to cover all possible problems or contingencies in a contract may be viewed as untrustworthy. Chinese culture values relationships known as guangxi and therefore relies more heavily on trust and verbal contracts than does US culture. In Brazil, however, there is a value system different from both the United States explicit contractual agreements and China's mutual trust and verbal contract. The Brazilian value system is known as Getino, in which people believe that they can always find a solution outside the legal contract on a case-by-case basis. If a culture does not respect the value of following through an obligation, no legal system, whether written or verbal, will afford enough protection to make doing business easy. There is no body of international law in the strictly legalistic sense. The key to evaluate an international contract and to determine which country's law will apply and where any conflicts will be resolved.
Arbitration and enforcement. Arbitration may be by a neutral party, and both parties agree to accept the rulings. However, if one of the parties does not fulfill its contracted requirements and does not respond to or accept arbitration, there is little the injured party can do. There is no international police to force a foreign company to pay damages. Intellectual property laws. Property that results from people's intellectual talent and abilities is called intellectual property and includes designs, novels, patents, trademarks, copyrights, computer software, etc. The philosophy behind intellectual property laws is to reward the originator of an invention, book, music record, clothes design, etc., for his or her idea and effort. Such laws are a very important stimulus to innovation and creative work.
It is possible to establish ownership rights over intellectual property through patents, copyrights, and trademarks. A patent grants the inventor of a new product or process exclusive rights of manufacture, use, or sale of that invention. Copyrights are the legal rights of authors, composers, playwrights, artists, and publishers to publish and disperse their work as they wish. Trademarks are designs and names often officially registered by which business people designate and differentiate their products. In 2007, the Organization for Economic Cooperation and Development (OECD) released a report estimating the annual value of international, physical, trade and counterfeited consumer products at approximately $200 billion. This equals around 2% of the entire world trade and exceeds the GDP of 150 countries. Apart from hurting legitimate businesses and trade, intellectual property infringement leads to the loss of government tax revenue. Piracy is most rampant in software industry. For example, according to the Business Software Alliance, a global anti-piracy watchdog group, 35% of the software installed in 2006 on personal computers worldwide was obtained illegally, amounting to nearly $40 billion in global losses due to software piracy. In percentage terms, Central or Eastern Europe topped the piracy rate at 68% of all software used, followed by Latin America at 66%, Middle East or Africa at 60%, Asia Pacific at 50%, the European Union at 36% and North America at 22%.
Antitrust laws. Countries have framed antitrust laws to keep a check on monopolies, anti-competitive agreements, bid rigging, unfair trade practices, collusive pricing. The US antitrust laws have their foundation in the Sherman Antitrust Act of 1890, the Clayton Act of 1914, the Federal Trade Commission Act of 1914, and the Robinson-Patman Act of 1936. US antitrust laws have been concerned with maximizing consumer welfare through the prevention of arrangements that increase market power.
The Sherman Act specifically forbade every contract, combination, or conspiracy to restrain free and open trade, but it was soon argued that the law was intended to punish only unreasonable restraints. In the Standard Oil case of 1911, the courts ruled that an act must be unreasonable restraint of trade for the Sherman Act to apply. Towards this end, a distinction developed between cases in which a rule of reason should apply. Second, cases considered to be per se violations of the law. The Clayton Act strengthened the US antitrust arsenal by prohibiting trade practices that were not covered by the Sherman Act. It outlawed exclusive dealing and price discrimination. Both are subject to the rule of reason. That is, they are unlawful only if the effect may be to substantially lessen competition. This concept even applies to any imaginary threat to competition, no matter how shadowy and insubstantial, as being reasonably probable of restraining trade. Concurrent with the enactment of the Clayton Act, Congress created the Federal Trade Commission and empowered it to enjoin unfair methods of competition in commerce. Prior to the Fair Trade Commission, violations of antitrust laws were the jurisdiction of the Antitrust Division of the Justice Department. Since 1914, the organizations have pursued dual enforcement of the antitrust laws with considerable, though some argue inefficient, overlap. The Justice Department focuses largely on criminal, price fixing, and merger review. The FTC, which does not handle criminal cases, concentrates about 60% of its total resources on merger review. The US antitrust laws were originally aimed at domestic monopolies and cartels, although the Act expressively extends coverage to commerce with foreign nations. Besides the United States antitrust forces, other countries have an organization that settles antitrust cases. The European Union is no exception. While the EU does not apply its antitrust laws extraterritorially outside the region, its laws are applied not only to EU member country companies but also to foreign companies as long as their corporate action has antitrust implications within the EU community. In India, we have the Competition Commission of India under the Competition Act, which tries to curb anti-competitive practices and also keeps a check on collusive agreements and one-sided contracts.
By far, the easiest way to assure what laws will apply in a contract is to clearly state the applicable law in the contract. If both a home country producer and a foreign distributor agree that the producer's national laws of contracts will apply to a contract for the sale of goods, then both can operate with a similar understanding of the legal requirements that they face. Similarly, to assure a venue that will interpret these laws in an expected manner, international contracts should stipulate the location of the court or arbitration system that will be relied upon for resolving conflicts that may arise. Let us now summarize what we have learned in this module. In this module, we have learned about the legal environment, which refers to the legal system working in a country and its importance. Some important treaties and conventions that we have discussed are Treaties of Friendship, Commerce and Navigation, FCN treaties, the Treaty of Rome 1957, Maastricht Treaty, the Vienna Convention on the Law of Treaties 1980, Paris Convention, and the Patent Cooperation Treaty 1970. We have also discussed the different types of legal systems, that is, common law system, code, written law systems, civil law, theocratic law or Islamic law Sharia systems, and socialist laws, different forms of legal risks and enforcement, intellectual property laws, and antitrust laws.